SJC-12405, Commonwealth versus Rashad A. Shepard.
Okay, Attorney Bolgan.
Good morning, Your Honor. May it please the court. My name is Claudia Bolgan. I represent Mr. Shepard. This case presents new and uncontested data proving that 82% of the people currently serving pre-Brown felony murder, life without parole, are black or brown. Only 18% of those 108 persons are white, and 60% of them are black.
Can I focus on the legal standard? Because the stats you put together are troubling and impressive, and we need to know this information. But I want to focus on the equal protection legal standard for a moment as applied to those troubling statistics, okay?
So the problem with equal protection is that...
Well, that's your claim.
I have actually a fairness claim that's bigger than the equal protection.
But you have a 33E claim, but you have an equal protection claim.
Indeed, but the equal protection claim is subsumed into a fairness claim.
Wait a second. There's an equal protection standard, right?
Yes. The equal protection standard looks... Did you
apply the equal protection standard?
Certainly, Your Honor. The equal protection standard looks for intentional discrimination. Right. Disparate impact is not recognized. And I think I'm asking this court to consider recognizing disparate impact in the equal protection context.
Okay, so you want us to change our equal protection jurisprudence?
Yes.
Okay, because the regular equal protection, as you well know, is a tripartite, because there's none of that in your brief. It's Bernardo B., it's Van Rader, which recently, but...
Exactly.
So you basically, that's why you didn't go into Bernardo B. or do the tripartite analysis? You want us to change our equal protection jurisprudence? I do,
under state constitutional law,
okay.
Which is, of course, within your discretion.
Right.
But it's also...
So the stated purpose in Brown for prospective application was the fairness of the government and those charging decisions, as Chief Justice Gantz, then Chief Justice Gantz wrote, correct?
That's correct.
And your argument is it's had a disparate impact as neutral and as well-intended, perhaps, as that statement was.
Absolutely right, Your Honor. I'm arguing that here in 2023, in 2017, with the information that this court had at the time, the fairness balance went to the Commonwealth on the retroactivity question. But here we are in 2023, after the June of 2020 letter where this court committed to combating systemic racism, to combating, rooting out conscious and unconscious bias in our courtrooms. So here we are with this data.
Can you tell me, all right, we do away with tripartite equal protection because the government decision-making in this case is, ironically, is our decision, right?
Ironically.
Right.
Here,
but that's true, correct? So we're analyzing the decisions we've made not to be retroactive.
Indeed, and that's a little uncomfortable.
Sure.
Sure.
Which we shouldn't shy away from, and I appreciate that.
Indeed, and I appreciate you saying that.
Let me ask the question. So, given all those, and we have governmental decision-making, and it's an equal protection argument, your request is that this court not apply its equal protection jurisprudence, but change the jurisprudence to what?
I suggest, in answer to the Commonwealth's argument that any change to the state constitutional law equal protection standard would open the floodgates, would make every new rule.
Well, we've changed equal protection before. We did it in the stop and frisk cases. That's not the issue. I just want to know, rather than the floodgate argument, I want to know what our legal standard is, or what you propose our legal standard should be. I
propose a horrific disparate impact standard, because
horrific?
Equal protection is a bad fit.
You said horrific?
Yeah, I said horrific.
Okay.
Because that's what we're showing here.
Does any state have a model? Because I understand we can provide greater protection under the state constitution, but does any state has adopted something similar to what you're proposing, horrific disparate impact standard?
I don't think so, Your Honor. Mm-hmm. But again,
has any state done a disparate impact analysis?
In terms of equal protection, no.
Okay, so
because equal protection is not the best fit for combating systemic racism, as Justice Budd defined it in Long, which is a system that produces racially disparate outcomes independent of the intentions of the people who work within it. So my equal protection argument is a subset of my fairness argument, because if this court wants to address the systemic racism shown by the statistics, there's a number of different ways this court can do that. If there are problems
About the horrific disparate impact standard that you're proposing, what's the control group? That is, you're saying the decision of this court to not apply Brown retroactively has resulted in a disparate impact, as opposed to what? The decision to apply it retroactively? Because it seems to me, or the decision that was made to apply it prospectively. Because if there is, let's just assume for purposes of conversation that there is systematic racism, then the people who benefited from the prospective Brown rule were disproportionately, as you call them, Black and brown. And so they benefited disproportionately, and then I don't understand what the control group is.
Let me address the control group. There is a baseline, and I hate to use the word baseline, but there's a baseline disparity in the DOC prisoner population that is mirrored almost exactly in the malice murder defendant population, which is approximately 60-40, 40% white, 60% non-white, Black, Hispanic, Asian, other. And that, pejoratively, I don't mean to say baseline like that's acceptable. It's not acceptable. But that's the baseline,
Can I
Your
ask
Honor.
to follow up on that? If you remove because one of the briefs, the BU brief, I believe, amicus brief, talks about the number of people in the 18 to 20 category. So if you remove the 18 to 20 disparate, which is 84% or something like that.
88, Your Honor.
88. Do you get to the normal prison population if you remove the 18 to 20-year-olds?
No, there's no way.
Mm-hmm.
There's no way. The horrific racial disparity
What does it
wording.
lower it to? I'm just curious.
I'm sorry, Your Honor.
What does it lower it to? Do you know the percentage it comes back to when you do that?
Well,
Because
I'm not
just
sure-
the numbers were staggering in the 18 to 20
Aren't they?
category. But
are.
that issue is also before us in another case. So I'm just wondering if you remove that category of people, what the effect is.
I don't think it would have an effect, Your Honor, because
it's gotta have an
30%, I actually, out of all the numbers that I have, removing the Mattis Robinson cohort was not one of them. But
We can do that math. You don't have to do it.
thank you, I appreciate that. Math is maybe, perhaps.
We'll do that in our leisure. Yeah.
But with regard to that, Your Honor, obviously no one knows what those cases are going to hold, but that's 32 less
I'm just
people.
trying to understand the practical effect of what you're doing based on, again, I wasn't here the first time, but the Gantz decision talks about the problem of going backwards. The Commonwealth couldn't have didn't know it had to use malice, prove malice. So what happens if you get what you want? We adopt this new constitutional standard, then what goes on in these 108 cases?
So
Retry everybody? I'm just trying to understand what you do.
If the BU brief does a good job of positing out to the practical implications of either a constitutional change or simply a common law
So
change.
what happens to those 108 cases?
I would advocate for blanket parole eligibility. And if that was not acceptable in this court's discretion, this court has full discretion in any way to deal with this issue, individualized resentencing.
Blanket parole eligibility, meaning that everyone's immediately eligible for parole?
With regard to what perhaps a second-degree murder 15-year sentence would be. Yes, parole eligibility, Your Honor. And then the fairness to the Commonwealth because that is a concern, comes back in at each individual parole hearing or each individual resentencing hearing, that if the Commonwealth had strong evidence of malice, that it was that it didn't produce a trial in reliance on pre-Brown law, they could produce it at that time to keep in each individual person accountable for their actions. And it's 108 people. This court has done many things recently that were affecting many more defendants. So a floodgates argument doesn't really wash when there's 108
Ask you
people.
on the floodgate issue, does a horrific disparity equal protection test apply to facially neutral drug laws?
That would be in this court's discretion. Because, again, equal protection is not a perfect fit for combating systemic racism in all its forms. That's a big question,
That's what
Your
equal
Honor.
protection, if anything is designed to deal with systematic racism, it's the equal protection clause, isn't it? That's the go-to constitutional provision to deal with equal protection violations.
Your Honor, if that's true, then it's done a pretty poor job. And that's what I'm coming back to you here today
But
with.
doesn't that raise what they're going to argue, that it's a global, I mean, we're talking about reanalyzing all different types of cases, not just these, right?
In your discretion, you could make a constitutional new rule that would have those problems, or in a common law manner, as Brown has been applied from 2017 to now, this court has complete discretion, non-constitutionally, to implement fairness here and leave the rest for another day.
Under 33E?
Yes. Fairness and justice is my argument. If that means equal protection, I'm happy to discuss that.
Didn't in Brown, and actually even in my decision, we applied 33E to Mr. Brown's case.
Yes, and I'm asking for the same here.
And the reason we did that was based on the facts of the person on the outer limits of the joint venture, correct?
Yes, absolutely, and that is my second argument.
Right, you're arguing that.
So my second argument,
That argument that your client should receive on the facts.
certainly. So completely separate from the retroactivity argument is the 33 argument. And the racial disparity data is pulled back into that. So that's where it comes into play with my client's particular case. But I'm arguing for Mr. Shepard.
Because the fact that he's black, is that the fact that we're?
No.
Okay.
That's
the
that's
33
the
argument, though?
that's the predicate. This case would
fact that
have
the
been.
No,
felony
can we get the answer to, please just give us your 33 argument on the facts.
So the deficits in the Commonwealth's case on culpability, there's 10 main deficits. And so with those deficits in place, putting the racial disparity back into it leads to the conclusion that were Mr. Shepard white, this case would have been prosecuted differently. So there's 10 main problems with the Commonwealth's case as to Mr. Shepard's culpability. First of all, Jones was a very unconvincing star witness. The DA in her closing argument called her despicable. The Commonwealth's brief also acknowledges she was unconvincing and credulity straining. So that's their star witness. So that's the first problem. The second problem was there was trial evidence that this lady was actually the shooter. The third problem is that there was information about the star witness that was not brought out at trial, but was brought out in the motions for new trial, which is a month before this. She had a gun in her apartment, and then I'm not suggesting this would have been trial evidence, but after she got her 5 to 7, she got out and was promptly arrested for possession of a high-capacity firearm with 13 hollow point bullets and a suppressor barrel. So that's the credibility argument of their star witness. But even that aside, this unconvincing star witness didn't actually testify to what Mr. Shepard's role, if any, was in this struggle in the apartment. And in fact, the first...
There was It was just that nobody saw what happened. There was just a gunshot, correct?
Correct. And the first motion for new trial made a finding. No testimony described his involvement in the struggle. So she testified she never saw my client with a weapon. So this is, going back, okay, let's look at her testimony if that's their star witness. Never saw him with a weapon. Didn't see when he left the apartment, whether it was before or after the shooting. So that's another difficulty in the case. She testified to his presence earlier in the evening at the planning, but she never testified to one word that my client said evidencing agreement. Testimony was to presence at the planning. And the Commonwealth points
They're
to...
all jury questions. I mean, the defendant, the cross-examination of Jones is vigorous and portrays her in all the negative whites you're talking about. There's all kinds of evidence that the other two are in the place, right?
Right.
And that
Absolutely.
the angle of the shooting comes. The best thing you've got is that the felony that he's found is unarmed robbery, right?
Right. There's
That's the best you've got. The other stuff are all jury questions, right? How old is he? I can't remember.
He was 25 at the time, Your Honor. So respectfully, I disagree.
And he had a gun too, right? There's evidence about him having guns as well, or am I mixing the two cases we're hearing?
There's
today?
no evidence of him having a gun. So respectfully, Your Honor, I'm not making a sufficiency argument. What I'm doing is I'm showing all the problems with the Commonwealth's case. And then my next argument is that given the problems with the Commonwealth's case on culpability, the data tends to show that if Mr. Shepard had been white...
Well, let me ask you about that assertion. That smacks of equal protection. I know there's cross-pollination with your argument, but if he was white, he'd be prosecuted differently. That requires proof or evidence of similarly situated persons not being charged, white people not being charged with felony murder, correct?
That data is largely unavailable. And trust me, I looked for it.
How is it unavailable?
Because prosecutors' charging practices are not data-driven. Were we to have those sorts of data, then I could come here with that. And data...
Could have plugged that into the tripartite analysis if you had that data.
Indeed, but the difficulty in obtaining data, Your Honor, I cannot overstate how difficult that is. At the moment,
In Bernardo B., we said it was actually easier, and in Van Rader, we said it was actually easier with prosecution's decisions. That's why we eliminated that for police officer on-the-spot investigations, right? So we had said that in Bernardo B., of course, they had prosecuted all the males in consensual sex statutory rape cases, and we could look at that. Mm-hmm. And here, you can't say that these people were charged with murder. There was a robbery in a gas station, and they weren't charged with felony murder, the white guy?
So I will respond to that by saying we are dealing with unconscious bias here. The data shows that almost no white people are convicted of felony murder.
That's a different issue. The issue is whether or not they're similarly situated and not charged.
And that is data that I don't have because it's not available, at least in this Commonwealth, and I've looked across the country as well, anticipating that this would be an issue.
Who did the data? I haven't read the whole record here. Is there a statistical expert brought in to do the type of comparisons you're talking about, or are you just taking these numbers yourself and running? Do we have experts here doing this analysis, doing what is the pool we should look at, which murders should be excluded from this, which ones are relevant, or is this all done by lawyers?
This was done essentially by me, Your Honor.
So we don't have a statistician of any kind saying, I mean, again, I didn't go to MIT like one of my colleagues and take statistics, but we normally have experts who do standard deviation analysis, make sure we're comparing apples to apples, not apples to oranges. We don't have any of that here?
This is relatively straightforward.
Well, there's nothing straightforward about statistics when we're dealing with the entire criminal justice system. and felony murder, right? That's a,
Which is one of the reasons I was asking you about the comparator data. Like, what do we compare? What's the control group?
The control group here was malice murder, Your Honor. The
But why is that the appropriate control group?
because malice, proof of malice is the difference between pre-Brown historical felony murder and
That I
first-degree
understand, but
murder.
it doesn't, mathematically, that doesn't compute.
With regard,
That would be your baseline, that would be your control group.
the control group, I would submit, is correctly malice murder, Your Honor, because what we're looking at here is a pool of folks that are doing life without parole for one type of murder that doesn't have malice as a component, and a pool of folks doing life without parole for malice murder. So the difference.
Tautology.
But I'm-
Why is that the right control group? I mean, that's the control group that you compared it to, but I don't understand why that would be it.
Isn't Justice Gaziano's suggestion the actual control group? And I mean, it's the Bernardo B thing, and why wouldn't you be able to find information, data about white people who are in the same type of situation but don't get charged with felony murder? It seems like that would be the way to prove this.
The only study I was able to find was in Minnesota. It's cited in the BU amicus brief, where in that state, due to the data laws, they were able to try to figure out what this upcharging and overcharging situation was with regard to that state. The Harvard study in this state,
Well, what was the control group in Minnesota?
I believe that they were just looking at all of the murder prosecutions and attempting to figure out why Minnesota has the same disparity that we do. They were trying to.
Article in the record?
In the BU brief, it cites to the Minnesota study, I believe, on
I can
page
find it.
19.
Thank you.
I mean, I looked through the BU brief. You have, a bunch of studies that sort of suggest things, but none of that evidence is presented here. And do we even have to do this DA's office by DA's office? We're looking at, is the relevant group this district attorney's office, or is it, how they do it? Is there unconscious, are they really responsible for what the other DA? I don't have any sense that this has been done in a statistically valid.
The odd part about it is that it's not the DA's decision you're challenging, it's our decision on retroactivity.
Yes, that's right. And again,
You'd have to show that we've made retroactivity decisions in a disparate manner, and if we were to apply the tripartite analysis, which you asked us not to appropriately, we'd have to look at similarly situated people. And that's why you don't want us to do that.
in this case, the pool of folks that are the most similarly situated are the malice murder folks. And I recognize that Your Honor's difficulty with that, because that is just objectively the difference between the two.
I'm confused by that, though. If there's a killing of someone with no underlying, the killing is not, there's no other felony. Mm-hmm. Those groups are not relevant to this. Are they included in your statistics?
They would be, if they were convicted of malice murder, would be in the malice murder statistics, because
But again, are we comparing apples to oranges?
To me, that the comparator needs to be those who benefited from the rule prospectively versus those who did not benefit from the rule not being applied retroactively.
And Your Honor, it's probably not surprising to you to know that I've been trying to find that data.
Well, if we assume, as I said, systematic racism is still present after 2017, and that felony murder disproportionately affected Black and brown people, then the benefit of the new rule disproportionately benefited Black and brown people. Do you see what I'm saying?
I do.
That is, the people who benefited from the rule were disproportionately Black and brown, as well as the people who did not benefit from it. So if you compare those apples to apples, there is actually no horrific disparate impact, nor any disparate impact.
So I have two responses to that, Your Honor. First of all, the data I was able to uncover as to what has happened post-Brown in terms of prosecuting felony murder is that, by and large, there is,
Prosecute felony murder after that?
you can,
Yes.
it's a discretionary decision.
It's a truncated felony murder, but it's still there.
It's still, you can absolutely still prosecute felony murder. There was a recent decision, Commonwealth versus Darrell Fisher, exactly that. So Mr. Fisher is one of a handful, perhaps 5 or 6 folks that have been convicted of felony murder only since 2017 that I've been able to find. What I found, Your Honor, was a ton of manslaughter pleas. So it's very complicated. What happens after Brown? Would prosecutors decide in a felony murder context where they have an unintended homicide, they have a felony?
Because now we're really dealing with third-pronged malice versus involuntary manslaughter.
Exactly, and so that leads to the second part of my answer to Justice Wentland's question, which is continuing to prosecute felony murder with a, shall we say, expanded definition of third-pronged malice may result in the same disparities.
What did you find with the 5 or so cases as far as racial breakdowns?
Racial data is very hard to come by in the
You
state.
found 5 convictions or so.
Yeah, I found 5 convictions. At least 2 of them, with regard to Mr. Fisher and his co-defendant, were of Black people.
Right, but you're not suggesting that's a sufficient
No,
pool to make
I am
any-
absolutely not. But I did want to recognize, Your Honor, that this is part and parcel of attempting to get our arms around this systemic racist problem.
Can I ask, you cite, the BU brief talks about the Binder and Yanka study. And there's a quote here: the strikingly disparate patterns of felony murder charging and convictions suggest that felony murder is a crime prosecutors have seen little need to punish when committed by whites. That suggests there's some, what is that, by the way, are those statisticians or lawyers again? And is there a statistical underlay to this?
I don't believe.
It's not presented in this case, is it?
I don't believe that they are. They're law professors, and perhaps I don't think they're statisticians, Your Honor. What people have done in terms to get their arms around the situation is to go to the jurisdictions and take a look. What has happened with felony murder? What is on the ground? So we're coming here to show you what's happened with felony murder is that in all these states, including Massachusetts, and
But you just don't have an evidentiary record for this. You're sort of, without any statistical expertise, putting this together. I just don't know, to make this kind of conclusion, don't we need an ample evidentiary record to support this, not your putting together these numbers by yourself?
well, Your Honor, the third motion for new trial judge, Judge McCarthy volunteered herself for remand. So if indeed this court is interested in this issue, but it just wants more data, wants statisticians, remand it to Judge McCarthy, and we will provide that.
Can I ask you a question? Does your 33E argument rely on this statistical data? Because you started talking about all the reasons why it's a fairness argument, but then you also said, but you're rolling in the racial disparities into that.
That's right.
Is that necessary for is that what we have to find in order to provide relief under 33E?
No. The culpability versus sentence argument, if this court has a problem with the pulling in of that racial disparity data, then it stands alone, because the culpability...
You'd be in the same position as Mr. Brown.
I would be. And Mr. Brown got 33E relief, and that is what I'm asking
right,
for.
That's what I meant.
Yeah, that's what I'm asking for. I'm asking for 33 relief with the racial disparity data and without it, due to the fact that the culpability versus the death by incarceration sentence here is not fair.
Yeah, no, we understand the argument. It just isn't clear to us, I think, that you've got the data to support that. There's numbers here, but they're not put together in a way that supports the argument. And I'm not, that's all.
Good.
It's an interesting argument, but we just don't have enough here to
Then, Your Honor, I would ask for a remand. I have a team of
Yes,
folks
before
that
you
would,
do that, just, can you go through a couple of your other legal issues? Because you've got 9 other legal issues in this case. Could you remind me, in Brown, and again, I wasn't here and I just don't remember the facts of Brown. Was Brown one of a getaway driver type of case, or was Brown in the room like?
He supplied hoodies and guns.
he supplied hoodies and guns.
Okay, all right.
Yeah.
So, any of your other legal issues you want to pinpoint? Because you've got 9 of them, but particularly the trial judges sort of over-questioning.
Yes, Your Honor. This was a very unusual trial when one reads the transcript. The judge asked 149 questions of the witnesses. The judge personalized the instructions on joint venture. My crazy, dumb brother-in-law, I would want my wife to have posted bail. There was an overarching unfairness here where the judge used this.
This is beyond folksy.
This is way beyond folksy. This is aligning with the prosecution. This is the worst thing that this trial judge
Was
did.
it clarification? I read through a lot of his questions. He does ask more questions than usual, but he seems to be just trying to clarify a couple of points. Where does he go beyond clarification?
He went beyond clarification in a jury instruction that commented on,
About his wife and the hypotheticals.
right,
Maybe not too folksy, but I don't know if they're really any. It doesn't look like he's putting his fingers on the scales. It just looks like he's showing off a little bit.
there was a comment that he made that in his jury instructions that expressly equated himself as the victim of an assault.
But in
That was quite
in
far
a way
over
that's
the line.
not going to be
Because we've had like transferred intent. There's this horrible SJC instruction on transferred intent, and some judges have said, if I shoot the clerk and I shoot, that, I'm sure you've heard or read that instruction before. Probably not a good idea. Mm-hmm. But have we ever said that stuff is forbidden?
No, Your Honor, but
I know
this is,
I know overbroad hypotheticals that relate to the case aren't a good idea and are error, right? It's more like that.
the cases are that you're referring to are these cases where there was one bad thing, and generally speaking, everything else was fine. That's not this case. This case is a constant litany, one after the other, of unfair
I just
things that were said by the trial judge.
Jones is critical, and you say there's something wrong with the way he gave the cooperating witness. What
do.
did he leave out, and why was that meaningful?
So what he left out of the Champa instruction was that the Commonwealth has no way of knowing that this witness is telling the truth. After Jones,
Doesn't he does say that
particular care. He gave the particular care
Right.
part of the Champa instruction, and my argument is that in light of what he said with regard to the lifestyle instruction, which could be,
Did the defendant ask for that part of the Champa instruction?
she did.
There's no objection when he gives the instruction, right?
There was an objection to the Champa instruction after the charge. She asked him to give the complete instruction, and he refused to do that. But that problem dovetailed with the lifestyle instruction, where he expressly told the jury that we're not here to judge someone's lifestyle, be it a witness or any other person.
Yeah, but he
And
doesn't direct that at Jones, and there's a lot of lifestyle problems here, because everyone's got a lifestyle that's problematic who's involved, right?
the problem here is that the whole defense was the lifestyle of Jones. Lifestyle was the code word for the defense. And that was the problem with asking the jury not to judge lifestyle. That was the defense.
I thought the defense was that he wasn't the third
Right.
party.
Based on the fact that Jones could not be believed because she was the only person who would testify that he came into the apartment and did what he did. And the reason the jury shouldn't believe her was because she was a gun-toting drug dealer who did the shooting herself. So the whole lifestyle shorthand for the defense was, don't believe Jones as to what she said.
Okay. Thank you.
Thank you, Your Honor. I would ask for 33E relief for Mr. Shepard or a new trial. I appreciate your time. Thank you.
Okay, Attorney Jansen.
Good morning. May it please the court, Catherine Jansen on behalf of the Commonwealth. I think I'll start with the equal protection issue. Here, I think it's clear under the law, if we're going to apply equal protection, disparate impact alone is not enough. And even looking at the statistics provided by my sister, which I'm not sure it's enough of a record, as this court had noted, to show that.
It would have been nice if you actually dug in and pointed that out, right? You kind of just gloss over all the statistics and leave us to, unwinding them, right? You kind of concede on statistics, even though there's no statistical evidence in here.
Well, I think it was important to acknowledge what the statistics she did present show, that it does show that there tend to be more.
We're not used to, I think, having no expert statistical analysis and then the Commonwealth saying, too bad, let's focus on something else. Would have been helpful if you helped us show some of these, responded to some of these questions. But anyway, it's water.
Understood, Your Honor. But as this court has noted, and I think even in the wake of Long showing where there were troubling statistics there, you need to show that I think this has to be presented in a selective prosecution manner, that there are similarly situated white defendants who are not being prosecuted for felony murder. And I think it's not as hard as my sister says it would be to show the statistics that there were a murder occurred where there was a felony also, and the Commonwealth just chose not to go forward on the felony murder because they were white. I don't think the showing has been made here that.
Is that the showing? Because I thought the challenge was to our decision as to whether or not to make Brown retroactive. Do we have to go down to the prosecution's decision on who to charge felony murder, with whom to charge felony murder?
I think they're a little bit intertwined, Your Honor.
I'm wondering, this is to Justice Kafker's point, it would have been great to have some person who was a statistician who could tell us who the control group was, because the challenge decision is this court's decision in 2007, for all the reasons set forth in that decision, not to apply Brown retroactively. And what everybody seems to be talking about in the briefs is some charging decision on felony murder. Those are two different things. They are not unrelated, but talking about the latter doesn't help with the former. It doesn't solve that statistical question.
Understood, Your Honor.
So who's the proper control group to determine whether deciding Brown, applying Brown prospectively, even if we adopt a disproportionate, disparate impact analysis, what's the disparity as against what?
I think
nobody knows. At least the briefing hasn't told me.
I think that might be a fair characterization, Your Honor.
But your argument is the tripartite analysis controls, no
Correct.
matter how we apply it, or whatever the governmental decision is, as Justice Wendland characterized it, which is my view as well. It has to be, unless we change the analysis to horrific
disparities. And I think here, when we're talking about a floodgate, if we're changing our equal protection analysis based on whatever the statistics are, the floodgate is that would apply not just to the small group of people, but any case or any change in a statute or a new common law rule by this court. It would open the floodgate to a lesser standard, I think. And so that's what we're talking about. I think you should not change the jurisprudence, as my sister asked you to.
Can you address the trial judge's more than folksy insertion of himself into the trial?
Your Honor, I think it was probably very clear to the jury based on, this is the judge's temperament. He's very courteous and talkative for sure. I don't think when you look at it, when you read the whole transcript, the whole 9-day transcript, I think when you look at it, it does not, in my opinion, jump out at you. I think it was clear that this was his temperament, that he was courteous to everybody. I think a lot of the questions, when you look at the 140 or however many instances where the judge apparently inserted himself, a lot of times he's clarifying evidence or he's sustaining objections.
He does dig in a couple of times, you know, 5 or 6 follow-up questions, doesn't he? There are a couple of times where he's not just sort of, I didn't understand that. What do you mean? He takes over a little bit. It's kind of an interesting dynamic some of the time, right?
Your Honor, I think perhaps you might be referring to when Jones was testifying. She said it didn't seem like the defendant was paying attention to their conversation in the car, and there was an objection to that because she obviously can't testify about the defendant's mental state, and then the judge clarified what was going on in that conversation. I think when you're looking at whether or not it's improper for judicial questioning, you need to not necessarily look at the answer because obviously the case law is clear that even if there's answers favorable to the Commonwealth's case, that's not enough to show partisan nature. You have to.
I can't remember. There was another. I thought he was worse with maybe one of the police officers. There's like a 5 or 6 follow-up questions in a row.
Perhaps you're when one of the officers was looking to serve another witness who had been with the group and passed out in the car and they couldn't serve her.
Right.
I
He's
think
like
maybe
trying
that's what
to-
you're talking about.
Yeah, he's trying to show basically that they couldn't have found the witness, right? That they're looking for, I can't remember this, they're looking for somebody.
McMillan.
McMillan, yeah.
And I
That
would
was
not.
odd, wasn't it? I mean, it's just a lot of questions on that.
I don't believe so, Your Honor. I think it might have been 2 or 3 questions. I don't have the. Excuse me, it's 4 questions, and I don't think it's a fair. I don't think it's a fair inference from the way he was questioning that he's trying to show there were no other, that they had exhausted all remedies.
There, what is he doing there? I'm just trying to understand. What is your understanding of what he's doing there?
I think he's just trying to clarify what he did or didn't do. I mean, to the extent that, you know, was it totally necessary? Probably not, but judges are entitled to develop and clarify the evidence, and that's part of developing the evidence. And any claim of prejudice that could have resulted from that, the defense attorney on cross-examination was able to elicit aptly that he had not exhausted all remedies to serve that person. And to the extent that this court finds that the judge overstepped his bounds in potentially the number of questioning, which I would suggest did not occur here. This was a very experienced defense attorney who, if she had no problem speaking up, if she had found something objectionable in terms of the number or character of the question, she would have objected. But here this jury was very discerning, so it wasn't overly borne by the judge in anything he said or did in this case.
Can I ask you about the Champa instruction?
Sure.
Because what the judge doesn't give the standard line that the prosecutors can't know the truth, which is important because the examination is they're going to be charged with a crime if they lie, but then you have to tell the jury, but they don't know what the truth is. So the charging decision is colored by that information, and that's not included in the instruction. Isn't that error?
So I think what happened here.
Was the Champa instruction erroneous?
I think it was, but I don't think it's preserved error, and I want to state why. Here, obviously, the prosecutor did not elicit that she had to tell the truth. That came out unanticipated on cross-examination. So
Right,
it
but
was
then
before the jury.
The judge's responsibility, when you hear that evidence, is to give that instruction.
Correct.
to
And
temper
then
that.
at the end of the instructions, the defense attorney just asked for the full Champa instruction, and I would suggest that it's not preserved because she has to I think it's a duty as a litigant to bring a specific attention to the trial judge about what the issue is with more specificity.
The facts get raised. She asked for the full Champa instruction, right?
Right, and I think it would be helped to highlight with
And then did she object to the instruction as given?
She objected to the instruction as given after, her objection came after the final instructions.
Okay, then how is
So-
it not preserved?
Well, I think because she didn't state with specificity, excuse me, I'm tongue-tied, about what specifically, why that instruction was error. But even if this was error and it was preserved.
You have a discerning view of preserving an instruction.
I think I do think the case law is clear. You have to kind of state, not just give a general objection. I think that's more on the general side, and I think that's a fair statement about how this happened. But even if this was preserved, it's not reversible error because there was no vouching that occurred with the prosecutor in her closing argument. She did not mention the cooperation agreement and the fact that they should believe her because of the cooperation agreement, or that she had special knowledge independent of what was evidence before the jury about why Jones was believable. She absolutely properly argued that Jones was credible based on her testimony alone and her demeanor, but also based on the corroborating evidence presented that independent of her testimony, which was before the jury.
And we have cases on the lack of proper Champer instruction, correct?
Correct.
As to whether or not it's reversible error.
Correct.
What corroborated Jones? Remind me, what are the major corroborating
Sure.
factors for Jones?
I would suggest the China Bowl video was very important, corroborated Jones, that they were all three of them were together. It was important because the China Bowl video, when viewed in conjunction with the 8 Carlton Street video, the China Bowl video is very clear, and the Carlton Street video, I would say is not as clear, but when you view them together, you can see that the 2 figures in there, I think it's more than a fair inference that it is Tyler and the defendant. You see the defendant in the Carlton Street video manipulating his pants. I would suggest, and it was suggested in closing and was not objected to, that he could have been putting a firearm or securing a firearm in his waistband. You can see that he's not on his cell phone during that operative time. In the Carlton Street video, is about 2 minutes off. And so that's consistent with his phone records. The fact that Tyler is on his phone, seen on his phone in the Carlton Street video at the operative time, consistent with Jones's testimony and their phone records. You see them turning the corner. Jones said when the struggle began, and before she went to the bathroom, the defendant was standing in the doorway, and based on the trajectory, that's where he would have been standing, where the gunman was. And so I think the fair inference from the trajectory and the Carlton Street videos that the defendant was the shooter and standing there based on the timing of her testimony. As far as corroborating about how the scuffle occurred, there was, she said that the victim bit Tyler's finger, and that and then that DNA from his blood hand was on the passenger side door of her car. And obviously the CLSI was helpful, but it was not the linchpin of the case to put the defendant in the vicinity.
On the ineffective assistance claim, the second-degree felony murder instruction was not asked for, and there was discussion of it, and the co-defendant received that from Judge Lang, correct?
Correct.
Why isn't that ineffective, where the jury came back on unarmed robbery and rejected the other predicate felonies?
Well, I think it's not ineffective because, one, on this record, where there's no affidavit from the defense attorney, the defendant hasn't shown it's anything but a tactical decision, and I think it's fair from the record that this was a tactical decision where she acknowledged that in the Tyler case, there were completely different theories of the case. Tyler never said that he had a firearm or knew about a firearm. That was his theory, was always the defendant.
We're to infer there was an all-or-nothing defense?
I don't think you have to infer it. I think you can see it based on her closing argument. I think if she had asked for that instruction, her closing argument might have been very different. Her closing argument and her theory of defense was, you can't believe Jones. The defendant was not here. Look at the phone records. You can see the timeline to show, like, why would he be calling her if he wasn't there? And I think that's a reasonable tactic decision under Roberts, which is cited in my brief, and Pagan, that it's not manifestly unreasonable to forego a certain instruction that might allow lesser included degree of guilt when you're going all or nothing. It's not, I think we very well could be here on the flip side if she had requested this, saying she's ineffective for having inconsistent defenses. So on this record, you can't say that it's anything but a strategic decision. And sometimes, decisions pan out how they pan out, but it's not unreasonable.
There's no evidence on the gun, no fingerprint, nothing on, was the gun ever found? I can't
I
remember.
don't believe the gun was ever found, Your Honor.
Right.
Obviously, any evidence from the gun would have been helpful, but although it's just from experience, it's hard to get evidence off of a gun generally. And I'm happy to answer any, I mean, there were a lot of issues raised, so I'm happy to, answer any other questions the court may wish me to address.